I can see one in Phoenix X6525 has just joined the meeting. Is that the Claimant's Council? Claimant Council, are you in this meeting? Hello, the court will go ahead and read the judgment of the court. The registrars have confirmed that they spoke to the Claimant Council earlier. So is aware of this. So I will go ahead read the judgment of the court. 19th day of July 2023 against the defendant the sum of 1 million naira only owed as at 6th day of defendant. 2. Can you hear me, defense counsel?
My lord, for about a minute, we couldn't hear anything. I think maybe it's the network, my lord.
I was knocked off, but
As the court, please.
So I'll start all over.
As the court, please.
By the day of June 23, the defendant the following. They claim 1. The claimant claims against the defendant is 699,067 naira only, being the sum admitted as outstanding salaries and emolument as at June 6, 2022, when the defendant ceased to be in the employment. 2. Interest on the sum of 1,099,000 until the of the claimant's case is that he was in the employment of the defendant between 6th of December 2022 as a chief operations officer by the data dated 6th of December 2021. As a result of the claimant was paid half salary in the month of April and no salary was paid in the month of May 2022. Ultimately, the appointment of the claimant was terminated as at the time of termination was indebted to the claimant for the salary of 2022 and full salary of May 2022, 1 week work June, 1 month salary deductions and pension contribution. The total indebtedness of the defendant to the claimant as at 7th of June 2022 was 2,425,834 naira. The claimant as follows. Outstanding April 339,334 naira, 339,334. May salary was 6,000 naira. June salary 2,500 naira. The subtotal 834. Also, one at the rate at 1,000 naira. Pension deduction 302 naira. 7.5% reduction at rate of 3,000 naira, and this for 1 million naira came to 2,004,834. A claimant wrote to the defendant through his solicitor salaries and allowances accruable to the claimant by the letter dated 27th of July 2022, which the claimant put at 2.425834 naira. That acknowledged the said letter, and the defendant, after making some deductions, agreed to pay the claimant the sum of 1 9.06. By the end, hello?
Yes, my lord. We lost you from the point where you said.
No, the network is really terrible today.
Yes, my lord. Where you said that the defendant acknowledged and agreed to pay 1.906 million, I think. That's the last thing I got, my lord.
Okay, so the claimant and through his solicitor demanding the outstanding salaries and allowances accruable to the claimant by the later dated 2022, which the claimant put at 2.425.834 kobo, 834. The defendant acknowledged the said later, and the defendant, after making some deductions, agreed to pay the claimant the sum of 1.699.067 by the end of September 2022. However, the defendant has refused to pay the claimant the sum agreed via the defendant's own letter applied to the defendant's counterclaim. The claimant challenged the defendant to the stricter proof in all the device. As a result of the defendant's counterclaim, the claimant challenged the defendant's proof in all the defendant's averment and instead insisted it was the defendant who initiated the 13th of August 2022 in response to the claimant solicited the 27th day of July. Additionally, the claimant clarified that the defendant's letter dated 16th of 2022 was not prejudice, and same was written on the advice of the defendant's solicitors. Claimant also added that the defendant was stopped from raising any issue concerning the queries alleged, as the defendant had already fined the claimant 44,000 naira and 28,000 naira 66 naira 67 kobo, which sums were deducted from the salaries of the claimant for February 2022 and April 2022 respectively. The claimant also noted that the defendant pays salaries in arrears. At trial, the following documents were tendered to the claimant and they were admitted and marked as Exhibit C1 to Exhibit C. Now to the defendant's case. The defendant, on the other hand, agrees that the claimant was in their employment until sometime around the 7th of June 2022 and was employed as a chief operating officer by the letter of employment dated 6th of December 2022. Also agrees that they are in the, but in addition, they also provide solutions. The defendant that it owes the claimant the claimed sum or any breakdown at all prepared by the claimant, and agrees that it received the claimant's letter dated the 27th day of July, but that their own offer letter dated 16th of August agreeing to pay the sum of 1.69907 prejudice against the defendant's right against the claimant for gross negligence and dereliction of duty while in the employment of the defendant. The defendant claimed, in fact, that their offer letter was never accepted by the claimant despite the reminder mail sent on the 27th day of September 2022. The defendant also denies any liability for interest on the alleged sum. The defendant tendered the following documents and same were admitted and marked as Exhibit C, Exhibit D1 to Exhibit D5. The counterclaim. In addition to their defense, the defendants hereinafter referred to as counterclaimant made the same amendments in their statement of defense. The counterclaimant averred that the claimant's action and omissions during his employment put the counterclaimant's relationship with their key clients at great risk. For example, Chickerson Group, one of the counterclaimant's main clients, who is on a 3,229,000 naira monthly and 38,758,824 naira annual retainership with the counterclaimant. That the claimant in one instance published the wrong version of a press release on behalf of the client, and in another instance, on or about the 14th day of April 2022, Chickerson Group requested that the counterclaimant company handle some creative work which the claimant failed to do. These acts and omissions of the claimant put the counterclaimant's relationship with Chickerson Group at great risk, for which they suffered damages. Accordingly, the counterclaims against the claimant the sum of 1,614,951 naira only, being damages for gross negligence and dereliction of duty while in the employment of the counterclaimant. In the body of the judgment, the defendant's final address is here. The claimant's final address. So I'll go straight to the court. Okay. Counsel and considered all the processes filed in this suit. It is my view that the following are the issues of determination. 1, whether the claimant led sufficient evidence to prove that he is entitled to the reliefs he claims. 2, whether the defendant is entitled to their counterclaim. On issue 1, it is important as a preliminary to address the issue raised by the defendant in his written address as to whether the claimant competently carried out his duties and obligations to the defendant when he was under the employment. I have perused all the processes and the reliefs in this suit, and I cannot find where the claimant contended unlawful termination or wrongful dismissal. Most so, in the statement of claim, the claimant did not bother to make any averment as to what transpired that led to the termination. It is the court's thinking that the claimant took that route for reasons best known to him. The claimant made it clear in the second arm of paragraph 4.03 of the final written address unlawful termination of employment or wrongful termination. It is claimant's submission that the defendant thought it wise to raise this issue as a justification for terminating the employment of the claimant. All records and purposes have been duly noted by this court. Most so, the claimant under cross-examination had already admitted to tardiness standard as an. When asked by the defense counsel, and I quote, "Did you ever do anything while in the defendant's company that would characterize you as a bad employee?" The claimant replied, and I quote, "There have been cases of tardiness." When further asked above or below standard, the claimant replied, "It is below standard." Now, to the main issues. The claimant claims against the defendant the sum of 1,699,067 naira, being the sum admitted as outstanding as salaries and emoluments owed as at 6th of June 2022, when the claimant ceased to be in the employment of the defendant. The rule is that he who accepts must prove. It is also the rule that anyone asking the court to enforce a claim right based on specific facts bears the burden of proving those facts. See section 131 of the Evidence Act 2011. Equally so, the burden of proof in every civil proceeding must be discharged on a balance of probabilities or preponderance of evidence in accordance with section 134 of the Evidence. Also honor Buchere versus Esegine, citation provided. The claimant's case is built mainly around Exhibit C for this. August 2022, being the defendant's reply, and the claim will rise it. From the facts of the claimant was in the employment of the defendant between 6th of December 2021 and 6th of June 2022. Terminated by dated 6th of June 2022. It was stated in the termination letter that the claimant's salary for May will be paid along with the other payroll, subject to when the company assets in its possession and a handover note are received by the defendant. The claimant averred in paragraph 4 of his witness statement of oath that, and I quote, by the letter of the defendant dated the 6th day of June 2022, my appointment was terminated. At the time my appointment was terminated, the defendant was indebted to me for the balance of April 2022 and the full salary of May 2022. 1 week worked June 2022. 1 month salary in lieu of notice, pension deductions, and pension contributions. The total indebtedness of the defendant to me is 2.25.83 naira. End of quotation. In fact, statement of fact, it was based on this indebtedness that the claimant sent the defendant Exhibit C3 a letter of demand for salary owed, dated the 27th day of August 2022. In this one-page letter, breakdown and arrived at the demand of 2,2.425.834 naira. It is also in evidence that the defendant replied through Exhibit C form their own breakdown after some deductions and arrived at the sum of 1.669.067, a sum less 6,000 naira 700 and the claimant's original demand. Clearly, the claimant decided to forfeit his original sum in favor of the defendant's own breakdown in Exhibit C form for the avoidance of this exact sum that is in the statement of claim. More so, the defendant's witness already testified under cross-examination that the claimant's claim before this court is not different from the sum the defendant approved for payment. The defendant did not deny making the offer in Exhibit C4. However, they contend that Exhibit C4 was made in the process of negotiation and hence made without prejudice. The issue of whether the document was made without prejudice is somehow the crux of the main suit, as there is no dispute as to whether the offer was made at all. The claimant had argued in paragraph 4.04 of the final that Exhibit C4 was not marked with prejudice. This dispute, as the claimant had answered in the affirmative under cross-examination that, and I quote, it is not there when he was asked to point to the court in the letter where it says the letter was written. And defendant, the argument was that it did not matter whether it was so marked. Indeed, it is the law that documents made or marked without prejudice are inadmissible and significant. In Farami versus NBA, citation provided, the Supreme Court reasoned as follows, and I quote, "Offers of compromise made impliedly without prejudice against the party as admissions, for the law has as its policy the protection of negotiations bona fide entered into for the settlement of the quotation." See also Ashaka, same AM Investment Limited, citations all provided. There is no disputing the fact that documents marked without prejudice are admissible. And I also agree with documents made in the course of negotiation are equally without prejudice, whether marked. It is irrelevant whether they are expressly marked without prejudice. See Uniabuji versus Amcon and Akambi versus Alatade, citations are all provided. More so, the law protects all statements made during bona fide attempts to settle. This was enunciated in International Nigerian Limited citation as follows, and I quote, "It is the policy of the law that disputes should be amicably settled, and it will be for parties to enter into negotiations if state negotiations were admissible in evidence to settle was not successful. Where such negotiation is by without prejudice, subsequent and even previous admissions made during a bona fide attempt, any correspondence made during a bona fide made along the line of bona fide settlement of expressly marked attempt between Chief Laddie Williams, SAN, and the appellants are inadmissible. End of quotation. Now, the above authority will lead us to an accompanying issue position between parties. Although the claimant later considered that documents made and marked without beginning from paragraph 07 is final written address between parties whatsoever, the general rule of law is that he to convey negotiation between the at any given time before this have all the exhibit tendered before this court representing the correspondence shows the parties were in negotiation. More so, after the termination of the claimant's employment in Exhibit C to dated 6th of June 2022, where the claimant was simply fired without more, there was no further communication from defense 16 day of the two, when the defendant replied the claimant's letter of demand with Exhibit 6 and I quote, "This is to inform you that Mr. John Obasi will be paid his outstanding salaries as follows." End of quotation. The sum of 1.699.067, while making further statement that note that we will start payment by the end of September 2022. Of exhibits, which is already evident take this now. The above company issue as to whether there was between parties. Although the claimant later said that documents made in the course of negotiation marked without prejudice, argued beginning from paragraph 4, his final written address, that there was no negotiation between parties whatsoever. The general rule of law is that proof C.Ojomo versus CJ, the defendant is bound or show particulars to convince the court that there was a negotiation between the claimant and the defendant at any given time before the suit. I have perused through all the exhibits tendered before the correspondence between the claimant and the defendant, and no clues show the parties were in negotiation. More so, after the termination of the claimant's employment in Exhibit C2 dated 6th of June 2022, where the claimant was simply fired without more, there was no further communication from the defendant until the 16th day of August 2022, when the defendant replied the claimant's letter of demand with Exhibit C for, I quote, "This John Obasi will be paid his outstanding salaries as follows." End of quote. The defendant then arrived at the reduced sum of 1.699.067 while making further statement that kindly note that we will start payment by the end of September 2022. End of quotation. The letter further says, also note that Mr. Obasi is not entitled to claim in the demand letter based. End of quotation. So this court, the above are conclusive statements and do not sound like any kind of negotiation. No kind of ongoing communication at all between the claimant and the defendant can be deciphered to subscribe of thought that there exists some kind of negotiation at any point in time. So it is duplicating to attempt to veil an of liability in Exhibit C 4D4, when more the defendant's witness under cross-examination maintained that without prejudice is not indicated on Exhibit C4 and not necessary for the claimant to respond in writing to the termination letter. Again, the contents of Exhibit C4 appear conclusive and final and do not presuppose the idea of any negotiation. It is irrelevant whether the claimant responded to them, assuming he was expected to. Furthermore, the claimant had testified under cross-examination that, and I quote, "I don't have access to the email. I downloaded the email letter to which came as an attachment, but I don't have access to the email anymore." In the quotation. Again, under re-examination, the claimant is recorded as follows. Where were you requested to reply to that? Where were you requested to reply to that letter? No. Reply to that letter. He said no. Was there any email requesting for a response for Exhibit C4? No, I don't recall that email. After considering the foregoing side, it is a finding of this court that Exhibit C4 was not made without prejudice and is therefore admissible. Furthermore, defendant contended that the claimant, having admitted his gross misconduct, the court should not allow him to benefit from his own negligence. He submitted that following the claimant, that allowing the claimant to recover the purported salaries and emoluments for the period during which he was engaged in gross misconduct would enable him to benefit from his wrongdoing. I do not find this argument to be valid. Although under cross-examination, defendant's witness initially denied punishing the claimant for his infractions by deducting sums from his salary, she eventually corrected her position. For the avoidance of doubt, here is a portion from the cross-examination of the defendant's witness. For any infraction of an employee of the organization, your company punishes the employee. She said, yes, correct. For Exhibit D2, the queries you punish the claimant by deducting his salary for each query you issued. And the answer was not queries. For the other issued, were they deducted? There were no deductions. Look at Exhibits C5 and C6. Those are deductions for months of February 2022 and April 2022. Is that correct? She said yes. Look at paragraph 10, the witness statement, which was read aloud in court. D4, paragraph 1. That is the punishment. The content of Exhibit C4, which is already evidence, this is to inform you that Mr. John Obasi will be paid his outstanding salaries as follows. 1. Outstanding salary for April 2022, 310,667 naira. After final deduction of 28,667, in brackets 7,000 naira for 7 days lateness and 21,667 naira his 1 day for not instructing his team to put out creatives for our client Chickerson. End of quotation. Regardless of the defendant's witness responses during cross-examination, the law is that the document speaks for itself. See NIDB versus Olalomi Industries Limited citation provided, where the court held that, and I quote, a document speaks for itself. Oral testimony is inadmissible to vary, add, or to take away from the content of a document. End of quotation. In Ashaka Sem PLC versus AM Investment citation provided, the Supreme Court had this to say, and I quote, oral evidence is inadmissible either to add or to subtract from the contents of the document, as a document speaks for itself, with the result that parties cannot give evidence contrary to its content. End of quotation. On the strength of the above, it agrees that the defendant, having already punished the claimant by the deductions stated in Exhibit C4 and from the testimony before this court, is stopped from arguing that the claimant is not entitled to his claim because of his infractions. That the defendant is stopped from leaving off argument, as denying the claimant his claim on this basis would amount to double jeopardy. Overall, there is no difficulty in finding that the claimant has led sufficient evidence to prove that he is entitled to his claim. On the strength of my findings, issue 1 is therefore resolved in favor of the claimant I so hold. On issue 2, the defendant to be addressed as counterclaimant file the counterclaim against the claimant, / defendant to counterclaimant, still to be addressed as claimant, to the sum of 1,614,951 naira only, being damages for gross negligence and dereliction of duty while in the employment of the counterclaimant. Indeed, the counterclaimant had averred in paragraph 14 in their statement of defense that the claimant's action and omissions during its employment with the counterclaimant had put the counterclaimant's relationship with their key client at great risk. In paragraph B of the particulars of paragraph 14 of the statement of defense / counterclaim, he averred, and I quote, In one instance, defendant to counterclaim published the wrong version of a press release on behalf of the client. In paragraph C, the counterclaimant averred that, and I quote, in another instance on or about the 14th day of April 2022, the client requested that some creative work be handled by the counterclaimant company, which request the defendant to counterclaimant was responsible for carrying out. Finally, in paragraph D, the counterclaimant averred that, and acts and omissions of the defendant to counterclaim have put the relationship with the claimant at great risk, by reason of which the counterclaimant has suffered damages. End of quotation. Despite all the foregoing averments, there is no evidence before this court linking the claimant and the client, which is Chickerson Group, or any particular showing how the claimant's action directly led to the loss of the sum now being counterclaimed. The counterclaimant's witness was asked under cross-examination before this court as follows. Your witness statement on oath in your paragraph 7, you referred to a loss. Any correspondence before the defendant and Chickerson that you have the client, the witness. Look at paragraph 8. Tell the court the wrong version of a press by the claimant. The an answer to that. Furthermore, the claimant had denied liability to the counterclaim and, in fact, challenged the counterclaimer in paragraph 8 of his reply to state defense dated the 8th of August 2023 to produce the GTB bank statement between the counter and Chickerson Group from January 2022 to December 2022. Additionally, the claimant challenged the counterclaimant in paragraph 10 to produce the press release published and signed by the claimant. None of this was done at trial, which is considered fatal to the counterclaim. The law remains that a counterclaim is an independent action and must be proven on the balance of probability. The counterclaimant, like the claimant in the main action, has a duty to prove his counterclaim if he hopes to obtain judgment. In effect, the burden of proving a counterclaim is on the counterclaimant, as he is a party who would, if no evidence is adduced to establish it. See Oroja versus Adeniyi. See also Abe versus Damawa, and Access Bank versus Ogboja. Koro citations are all provided. Flowing from the foregoing, I hold that the counterclaimant has not adduced any evidence to prove his counterclaim, and therefore issue 2 hereby resolved against the counterclaimant. On the whole, relief 1 is hereby granted. On relief 2, it is tried that pre-judgment interest is awarded where there is an agreement of payment of an interest or under mercantile custom or under a principle of equity, such as breach of a fiduciary relationship. In such cases, a claim for unproven. Merely stating a claim for pre-judgment interest without proof of same is not sufficient. See UBA versus Oranugba, citations all provided. The claimant did not plead facts of entitling him to pre-judgment interest, this court cannot grant same. Hence, relief 2 succeeds only as to the post-judgment interest at the rate of 10% until the judgment sum is liquidated. On relief 3, while the court would have been inclined to grant same, unfortunately, the claimant did not state the actual sum of the cost of the action. The implication is that the court may not grant a specific sum for such costs, as release must be properly claimed and proven. Nigerian courts operate on the fundamental principle that they are not Father Christmas and will not grant relief that have not been specifically sought by the parties. CUBA versus that and Landmark versus Anwuli citations are all provided. The general rule is that the court will only grant release of claims that are properly asked for and proven. If a party merely pleads cost of filing suit without stating any amount and without providing evidence to substantiate the cost, the court may decline to award a specific sum for such costs. See Cumex versus Kogi State Government, citations provided. And the court will only grant in favor of a claimant's relief or claims properly asked for and proven. It is important to state that claims for the cost of an action, especially if it is sought outside of general damages, there must be evidence to justify this claim. The court cannot simply take judicial notice of the cost incurred, as held in Dogo versus Ashende's Associates, where, and I quote, the Court of Appeal held, A court is not a Father Christmas and therefore will not grant any relief not claimed and not proven. There must be some evidence to justify this claim. There must be evidence to show that cost was incurred as a result of prosecuting this case. The end of quotation. Therefore, even if cost of suit is mentioned as a relief, the absence of a stated amount and supporting evidence makes it difficult for the court to quantify and award it. Award for a specific sum for costs that was neither pleaded nor proven would be considered a nullity. See UBA versus Dana Motors. As the court is not a Father Christmas and as such, award will be set aside. See also NIC versus Ocheniechi and another citations are all provided, where an award of 300,000 as cost of was set aside because it was never pleaded by the first respondent. It was not stated anywhere as a relief sought. End of quotation. There is no contention to the court's inherent power to award costs, but case law dictates that this specific amount must be pleaded and proven. If a party intends to recover specific expenses incurred in prosecuting a suit, example, filing fees, professional fees, etc., this would ideally be pleaded with a specific amount and supported by evidence. In conclusion, the failure to state the amount in the relief and to provide evidence to justify it will result in a court not granting that specific sum, as it will amount to speculating on the amount. The court cannot be left to speculate and will not engage in speculation. See Ore, citations also provided. In the light of this relief, 3 is hereby declined. All sums awarded in this judgment shall be paid within 30 days from the date of delivery of this judgment, which the sum shall attract simple interest per annum until fully liquidated. The judgment is accordingly entered. This is the judgment of the court.
Thank you, my lord, for a well-considered judgment. Unfortunately, we were thrown out of the meeting because of rain in our area, my lord. I did catch that one of the reliefs was granted, I believe, and then the others were refused. We would apply for the certified true copy of my lord's judgment, but we would crave the court's indulgence to kindly reiterate the award made against the defendant, my lord.
Okay, that's paragraph 52. On the whole, relief 1 is hereby granted. On relief 2, it is tried that prejudgment interest is awarded where there is an agreement of payment of an interest or under mercantile custom or on such as breach of his fiduciary relationship. In such cases, interest must be pleaded. Barely stating a claim for prejudgment interest without proof of same is not sufficient. See UBA versus Aranuba. As the claimant did not plead facts or present evidence entitling him to prejudgment interest, this court cannot grant same. Hence, relief 2 succeeds only as to the post-judgment interest at the rate of 10% until the total sum is liquidated. Relief 3 was not granted, which is for cost. Okay.
As the court pleases.
The judgment is ready. You can come to the registry and pick it up.
Oh, much obliged, my lord. We are very grateful.
Okay.
We shall do the needful.
Okay, then. Thank you.
Thank you, my lord.
Okay, then.